Good morning, friends. Welcome to the YouTube channel Advocate Amit Kumar Gupta. In my series on the income tax cases, today I am going to discuss a very important case. The name of the case is Principal Commissioner of Income Tax and Another versus MPHASIS Software and Services India Private Limited. This judgment has been reported in 445 ITR at page number 468. The matter has been adjudicated by Karnataka High Court and the date of the judgment is 25th October 2021. Friends, in this particular case, the assessee was having some exempt income on the investments made by the assessee, and the assessee suo motu allowed some expenses against the exempt income and filed its return of income. When the assessing officer saw this thing, he didn't choose the case for scrutiny and he opted the route of section 154 for making the disallowance under section 14A and did not make any mention in the order why the disallowance has been made under section 154, why the disallowance done by the assessee is not adequate, and applied section 14A rule 8D. Friends, as we know that section 14A is a very debatable issue and it cannot be taken care of in 154 section proceedings. If you want to make the addition under section 154 under section 14A, then you have to open the case of the assessee either under section 143 subsection 3 or 148. But under section 154, only those rectifications can be done which are mistake apparent from record and which are not debatable. This is a settled law. In the number of the cases it has been laid down by the various honorable courts that a debatable issue should not be dealt in section 154 rectification. The assessee went to CIT appeal against the 154 order to the CIT appeal, but the CIT appeal also upheld the order of the assessing officer. That's why the assessee went to the ITAT. The ITAT said that assessing officer was not correct in making the addition under section 14A by taking the route of section 154 because section 154 allows only the correction of the mistakes which are mistakes apparent from record and which are not debatable. And the mannerism of section 14A is that if the assessee has done some disallowance for the expenses in regard to the exempt income and the assessing officer wants to go above that disallowance, then first of all the assessing officer has to find the fault with the method adopted by the assessing office by the assessee and then can make the addition, and that too after giving a proper opportunity of being heard to the assessee. So this procedure has not been adopted by the assessing officer and plainly section 14A addition cannot be dealt with under section 154 rectification. When ITAT gave the relief to the assessee, department went to the High Court and the Honorable Karnataka High Court held in favor of the assessee that whatever the additions has been done under section 14A by taking the route of section 154 is not as per the mandate of the law, is not as per the mandate of section 154, and these matters has to be dealt in the scrutiny proceedings whether it is under section 143 subsection 3 or 148. So friends, we see that the department for making the additions does not follow the exact procedure that what section should be adopted for making the various additions. 143 subsection 3 is a different section, 148 is a different section, and 154 is for rectification of mistakes. So in this particular case, the Karnataka High Court gave relief to the assessee. Friends, at the end of this video, I am once again repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus MPHASIS Software and Services India Private Limited. Thank you, friends.